Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to be talking about the right to know law, but as it applies to law enforcement. A couple preliminaries before we dive into the subject here. Excuse me. If you've never participated in one of these webinars before, it's essentially a PowerPoint presentation with me narrating, if you will. This PowerPoint, as well as all of the PowerPoints that we use for our training, is available on the Office of Open Records website. Scroll over to the training tab, go down, and you can find all of the PowerPoints. You're welcome to download them. It might be that you have a colleague or friend who couldn't attend this morning, and they would find it useful, perhaps only for your just future reference. Or maybe you're conducting some local training and you need some resources. Like I said, you're more than happy to avail yourself to anything on our website. This session is also being recorded, and the recording will be available a couple days after the session. I think the process is there's two ways. One is that it might be posted on the website, again, under the training tab. Also, if you contact the office, they can send you a link that gives you access to the video. And again, you can download it and use it for your own future reference or training or whatever your needs might be. Finally, you can join the conversation in the chat feature. If you have questions, I will do my best to answer those questions live, but I have two conditions. First is that just for the good of the group here, we're talking about the right to know law, so let's stay on topic. And second, and probably more importantly, is that if you can keep your questions as concise and as short as possible, it would be very helpful. Honestly, it's just awkward for me to sit here and read through several paragraphs while everyone else is waiting patiently. If it looks like you've got something unique to your particular situation or something unusually complex, we'll do one of two things. We'll wait until the end of the presentation and I'll try to come back to it and address it for the good of the order, or we'll take the conversation offline. The contact information for the office is on the screen right now, the phone number and the website URL where we've got email accounts, and you can reach out to our office. Typically what happens is the first point of contact will be one of our admin staff, and they are very well versed in the right to know law and can usually get you headed in the right direction. If you happen to stump them, then your call or your inquiry will be escalated to one of the senior staff, and we'll do our best to get back to you as soon as we can, and again, get you steered in the right direction. We cannot write requests for you. We cannot respond to your requests. And we cannot discuss active appeals, nor can we provide legal advice. That's just not our job. But what we can do is attempt to steer you towards situations that we've dealt with in the past where the facts are very similar. We have over 30,000 final determinations, which are the rulings that our office issues. I like to say we've seen it all. But just when I say that, something new comes around the corner. Nevertheless, we'll try and get you steered in the right direction with whatever issues that you have, and hopefully, provide the help that you need. Okay, enough of that being said, let's dive into the presentation. And the first thing I want to talk about is why is the right to know law important? And it has to do with access, transparency, and good government. And I'm going to read from, the preamble to the right to know law. Or, well, not really, but this is a statement that I consider to be foundational, where, when someone calls the office, usually it's an agency open records officer, and they have an issue. They're confused. Maybe they don't know which direction to head in. There's always a backstory, other facts that tend to muddy the issue. And I like to remind them the purpose of Pennsylvania's right to know law is to give the public access to public records. Okay, no more, no less. That's why we have the right to know law. Sometimes a right to know law request will come through, and it's vague, or it's written by the person's not an attorney, but they play one on TV, and there's all this legalese, and you're trying to sort through it, and you're just not clear what this person's asking for. Well, there are a number of things you can do, but a lot of times you can get back on track and headed in the right direction if you just remember what this law is all about. There's a common misconception that the right to know law is like some form of Google for state and local government, and that's just not the case. You'll get a right to know law request with all these questions, and then the expectation is that you're going to run around and find all the answers, and that's not how it works. The response, the appropriate response to a right to know law request is to determine whether or not, number one, the person is asking for records, and number two, whether or not those records are public and should be released into the public domain. That's pretty much black and white, okay? Now, that being said, you need to keep in mind that every record of an agency is presumed to be public. Okay, that's the starting point with the right to know law. Everything you have that is a record is presumed to be a public record. Now, if you receive a right to know law request, and let's say a red flag goes up, chances are there is a tool either within the right to know law or another law related that will give you the, I want to say ammunition, but that's probably an inappropriate term at this point. It will give you the tools to withhold that record from public disclosure, particularly with law enforcement. However, you need to keep in mind that it is the agency. And when I use agency, that's in a generic sense. We're talking about a state cabinet level agency, a department, a board, a commission, an authority created by statute. At the local level, we're talking about cities, boroughs, townships, school districts, by right of extension of that, public charter schools, and again, authorities. Those are agencies, okay? But it is the agency that bears the burden of proving that a record is not public. Okay, so let's do a quick review here. Every record is presumed to be public unless an agency can prove otherwise. If they can meet that burden of proof, then they can withhold the record from public release. And it is a legal level of burden, okay? It's not just thinking that, well, I don't think we should release this. Rather, you need to make a legal case. Now, that sounds rather daunting. People encounter this law for the first time. Maybe they get their first right to know law request and they think, oh my gosh, everything in the office is going to, end up on the front page of the paper tomorrow, or, someone's going to post it on their Facebook page. And like I said, that's not the case. Chances are, if you think that a record should not be released, there's usually a tool that will help you in meeting that legal burden. Okay, question has popped up here. Children, youth, and family. If we have an investigation and have reports from children, youth, and family, how would we handle the release of those reports? Okay, well, that's not really related to law enforcement. We do cover that in another webinar that we have about laws that protect information. And I think you'll find that there are other laws that protect, well, I know that there are other laws that in Pennsylvania that protect the release of reports related to suspected child abuse. Yeah, so I would just suggest, Danielle, that you look at our training calendar, and the next time we offer that webinar, you might want to sit in on that. It's called Laws That Protect Information, and we go into a little more detail the child protection laws, child line, and all that. Okay, so let's move on and discuss, what an agency needs to do if they fall under the jurisdiction of the right to know law. And the first and probably most important thing is that you need to appoint an agency open records officer, or what we call an ARO. This is the same thing as a right to know officer. The two terms are interchanged and commonly used by many agencies. Okay, so this can be anyone within the agency. There's no requirement that they be of a certain level, that they be a uniformed officer, no requirement that they be administrative staff. Some agencies will have one ARO covering the entire organization, including, the non-law enforcement side. Others will have like a separate ARO for the non-law enforcement side, and then someone just responsible within the police department. That's okay. You just need to make sure that, looking at it from the public's perspective, I've got a right to know request. Who do I give this to make sure it gets to the right person? Okay, so you need, within your office, and if you have a website, you need to post it on your website. You're not required to have a website, but if you do, you need to post the contact information. Again, how do I get a hold of the right to know officer, or the ARO? You need to have a form available for filing open records requests, and you can have your own, or you can refer to the state form, what's known as the uniform form. You can require that someone complete one of those two forms. If you have your own, that would be one. But if they come in, or if they submit it on the uniform form, you must accept that. Okay, that's accepted, must be accepted statewide. But you need to have blanks available, so if the person doesn't have their own form, you can give them one to complete. Then you have to have posted the applicable appeals information. Now, law enforcement can be a little different, but for the majority of cases, the person would file their appeal with the Office of Open Records. I'm going to get into the exception here with law enforcement, where it might be appropriate for them to file their appeal with the county district attorney's office. And like I said, I promise I'll get into that a little later. And then you need to instruct all of your staff to forward any requests that they might receive to the ARO, the Agency Open Records Officer, as soon as possible. And I say this because there are hard deadlines built into this law with no leeway. And if by chance a delay would occur with getting the right to know request to the ARO, the agency could be abrogating its legal right to respond to that request. And you would not be able to meet your legal burden. So you want to be very careful about that. Make sure that all your staff know if they get a right to know request, they need to get it to this ARO quickly, okay? It can't sit in somebody's outbox. It can't sit on the counter thinking, well, I'll take it downtown in a couple of days. You need to have a system in place to get it to them right away. And then finally, notify us who your AROs are. On our website, we have a searchable database for all the AROs statewide. Some of it is automatically populated, but the greater majority of entries are voluntary, where we rely on you to tell us who your AROs are. Then the database gets updated, and we realize people move on. They get promoted, they change departments, they retire, and the like. So maybe one of the takeaways this morning is to check our website, make sure your entries are up to date. If they aren't, there's a form there for you to fill out, send it to us, we verify it, then we update the database, and everything looks good. This is also important in the case of an appeal. This is the person we reach out to. Okay, another question has popped up. If you have an ARO for township admin and an ARO for police, can either ARO respond for either department? Well, Yvette, that's an internal thing as to how you work it out, which raises an interesting point here. I don't want to get in the weeds, but just something for consideration. Um, there is a law in Pennsylvania that I'm going to be talking about called CRIA, the Criminal History Records Information Act, where there are different interpretations, but I've had discussions with various police chiefs where they are concerned that in responding to a right to know request, a non-uniformed person having access to police specific records might in fact be in violation of CRIA. That's not an issue for our department, for our office to rule on. That would more appropriately fall under the Office of Attorney General. But it is a concern that some police chiefs have voiced. But again, it comes down to what your internal policy is for your township as to how you want to handle that. And maybe it would warrant a discussion between the township manager and the police chief to see whether or not you're handling that in the best way possible. Good question, Yvette. Another one's popped up from Tracy here. What is the process when an arrow is out of the office or on vacation and away from the office for a period of time? Okay, Tracy, you raise another very good point. And what if you only have one arrow? Ideally, you would have a backup who could step in and keep the process moving. But, some townships, some boroughs are small and they don't have the resources. They don't have the bench strength. Well, there is, in fact, a legal decision. You read the law and that tells you the basics of the law. And then you have case law, which is the result of litigation resulting from lack of clarification in the law itself. And this is one of those points. I think the appropriate case citation is Donahue versus the Office of Governor. And this was a case where the arrow for the governor's office was out of town for a while. And cut to the chase here, the decision basically says that the clock does not start ticking until the arrow receives the request. So if the arrow is out of town or on vacation, everything is on hold until they return. Then the clock starts ticking as far as the deadlines go. But it helps if everybody's on the same page with this. For instance, now, our office, we have 3 people who handle right to know requests, and they come into what's called a resource account. But let's say the office is closed for some reason. Well, typically, an out-of-office reply goes out saying that the arrow will return to the office on this specific date, and that's when the clock starts ticking. That way, the person submitting the request is aware. And this isn't in the law, this is simply a best practice. But that way, the person submitting the request is aware that the clock does not start ticking until a certain date. So it might be best if you have that capability with emails to have an out-of-office reply that notifies the requester what's going on, or maybe you can pick up the phone and give them a call and explain the situation. And that way, if there is a missed deadline and the person wants to file an appeal, we know what that agreed upon deadline is. Okay, so that's how that works, Tracy. Okay, moving on. There are some things that you cannot do related to the right to know law. And the first is that an agency may not limit the number of requests or the number of records that a person can request within a specific time frame. You can't say, ma'am, I'm sorry, you already filed 3 requests this week, that's all we allow. If she's inclined to file a dozen requests this week, the law allows that. Also, you cannot compel a person to tell you why they are filing a right to know request. You can't deny it based on the reason or what you think that reason might be. Now, let me go off script again here real quick. The The greater majority of people filing right to know requests are doing it for legitimate reasons. They have a problem. A record that you may have is going to solve that problem. So they file a right to know request. And usually they're willing to pay a nominal fee to get that request. But we also realize that there are a handful of people out there who, for whatever reason, the relationship between them and your department has broken down. Maybe they got a parking ticket. Maybe, they had a run-in with one of their officers. Maybe they just don't like the police chief for whatever reason. And they've decided they're going to be a pain in the neck. And one of the ways they're going to be a pain in the neck is to weaponize the right to know law. And they submit a lot of frivolous right to know requests. Well, my experience, and I was a right to know officer here at the Office of Open Records for about 8 years, is that the way to make one of these problem requesters go away lies in knowing the payment side of the right to know law. Okay, a legitimate requester is willing to pay a nominal fee. A problem requester usually isn't willing to spend a dime to be a pain in the neck. And that's how you make them go away. Now, we do offer another webinar on the right to know law and payment issues, where if that's, if this is a problem that you have, you might want to sit in on that webinar or give our office a call and we might be able to help you out directly. But that's how you deal with problem requesters. Okay, but the bottom line is that you can't force a person to tell you why they're filing a right to know request. You can ask, but they don't have to tell you. Okay, let's move on. And I like to describe the right to know process as an obstacle course, okay? The start of the race is when you receive the request, okay? Because like I've been saying, that's when the clock starts ticking. And there are deadlines within this process that we're going to talk about. And it's just like a race where, I don't know if you're familiar with bicycle racing, okay? But if you're really slow and having a bad day, there's a thing that they call off the back, where they just kind of tell you, look, you've had your shot. It's time to get off the course and let the other riders, finish or lap you or whatever. Right now, you're in the way. Okay, so that's kind of like how the deadlines work here. But on this course, we've got 2 hurdles that need to be jumped over. And in front of the second hurdle, there are 3 hoops that you need to get through before you can even get to the second hurdle. If you make it over the second hurdle, you're basically finishing the race. And from our perspective, you're saying, this is a public record. We're going to grant your request and give you those records. Okay, so we're going to kind of go through this process of looking at the obstacle course. And I think that will help explain a lot of what's going on here. Okay, let's talk about the deadlines. First off, when the arrow receives the request, they have 5 business days in which to provide an initial response. Now, a business day, typically, and realizing most police departments are 24/7 operations, but a business day is considered when is the administrative side of the office open for public business. Typically, that's Monday through Friday. Now, if the office, if the administrative side of the office happens to be closed for a holiday, or they're closed for a weather emergency, that's not considered a business day. Okay, you would skip that. But for most of our purposes, it's Monday through Friday. Saturday and Sunday would not be considered a business day. Okay, so if by chance you can't provide that initial response within the 5 business days, the right to know law allows you to unilaterally invoke a 30 calendar day extension. A calendar day is different from a business day. That would include Saturday, Sunday. That would include holidays. That would include weather emergencies. You would simply come up to what would otherwise be the 6th business day and count 30 calendar days. And that would be how you calculate that deadline. Now, for your extension to be valid, though, there are some conditions that need to be met. You need to invoke the extension within the 5 business day window. You can't wait until like this, what would otherwise be the 6th business day, suddenly realize, oh, I forgot about this right to know request. Well, I'm just going to take an extension. Unfortunately, you have denied the request by default when you allowed the 5 business day deadline to lapse. Legally, it's what's called a deemed denial. And if it ends up being a denial, which can then be appealed because you failed to meet the first deadline. You need to notify the requester in writing that you're taking the extension. And if they submitted the right to know request by email, well, then you can reply back to them by email that you're taking the extension. You need to notify the person why you're taking the extension. What's the reason? Fortunately, within the right to know law, you can go to section 902 and it lists 6 reasons that you can use, whichever ones apply. For instance, we keep these records off-site, and it's going to take us longer than 5 days to go dig through them and see what all we have. Or we're going to ask our solicitor to review the records to make sure we don't give out anything we're not supposed to. And it's going to take our solicitor longer than 5 business days to go through those records. So we're taking the extension for that reason. And then finally, if at any time during this process, the requester has the right to appeal because, either failure to respond during one of these deadlines or they receive a denial, the appeal process is such that they have 15 business days to file their appeal with the appropriate party, which could be, depending on the circumstances that I'll explain here in a little bit, either the Office of Open Records or the county district attorney for that particular agency. Okay, so first offhand, I'm going to get a sip of coffee. And then we're going to talk about the obstacle course again. And we're up against the first hurdle. To make it over this hurdle, we have to successfully answer a question. Oh, we have some questions that have popped up here. Okay, what about snail mail when the requester is incarcerated? It takes a long time for them to get a response. Yeah, you have to account for snail mail. For our office, I think the rule of thumb was 5 business days. I'm not sure where the courts are on this now, but I think, at the time, and this goes back a few years, 5 business days was considered a reasonable period to get the response. There may be instances where, it takes longer for the mail to get in and out because it's screened and so forth. And, I think it's on a case-by-case basis for determining whether or not the mail is timely and the right to appeals and so forth is timely. You just have to look at the specific circumstances and see how that plays out. I wish I could give you a more definitive answer on that, but I haven't dealt with that in a couple of years. But I'm pretty sure that's where we're at. When do you start counting those days? Okay. No, you would, okay, this is Michael. If you were to receive a right to know request today, tomorrow would be considered your first business day. Because, what if it came in at 4:59? Well, that's not really fair to you because you would not have a full business day. So if you receive the right to know request today, tomorrow would be, assuming that tomorrow is a regular business day for your operation, tomorrow would be your first business day. Okay, good question, Michael. Okay, so back to the slide here. The first hurdle, we have to answer the question, is it a record? Well, it so happens, and I always tell someone, if you're trying to understand a law, don't forget to read the definition section, because a lot of times, it can be written in legalese. The language can be vague. There can appear to be conflicting language within the law itself. A lot of times you can shed light on what the provisions of the law mean by reading through the definition section. And the right to know law is no different. And it so happens that within the right to know law, there is definition of what a record is. And it's any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, the key phrase here is highlighted. For a document to be considered a record, it has to document a transaction or activity of an agency. All right, so let's translate that into common English. It means that the document needs to document what it needs to be about what the agency is responsible for, what it does. Okay, now you're thinking, why would we have any other record or any other document that is not a record? Well, think about it. All day long, we generate communications that do not rise to the definition of a record. Okay. For instance, let's say I send an email to one of my colleagues. Hey, I hear a new restaurant's opened up downtown. Do you want to meet for lunch tomorrow? Or what do you think of the Eagles' performance so far this season? Do you think they have a shot at the playoffs? Or I'm going to pick up a pizza on the way home tonight. All right, all fairly common communications that have nothing to do with documenting a transaction or activity of the Office of Open Records. Therefore, because they do not rise to the definition of a record, I'm off the obstacle course. I don't make it over this first hurdle. And I don't have to worry about them being released in response to a right to know request because they're not records. All right. The other thing that you need to keep in mind here, though, is that there are a lot of agencies where you can use personal devices and personal accounts for conducting agency business. Just because I happen to use my cell phone to send a text, let's say I send it to our Deputy Executive Director, Nathan Byerly, and I said, Nathan, could you send me recent case law on police incident logs? And, because I'm developing some training language on this particular issue. Okay, clearly it has to do with the transaction or activity of the agency, but I'm sending it on my cell phone. Okay, so you need to be aware it's a record based on the content of the message, not how the message is sent or where the message is stored. Okay. Now, it's not always a good idea to use personal devices and personal accounts, but there's nothing illegal or nothing unethical about it. I can do that. It's just that I need to be aware that those messages on my personal cell phone or on my personal laptop are discoverable under the right to know law based on the content of those messages. All right, so that's something important to keep in mind. Okay, some questions have popped up. Ashley, we have had people come in that do not speak or read the English language. Do we need to provide the form in various languages? No, there's nothing in the right to know law that mandates that. We've encountered that in our office, and our position has been to rely on Google Translate for them to understand the form. We do not provide the form in other languages. We put it on the requester to use some third-party software. And the reason, quite honestly, is that way we don't bear any liability for potential misinterpretation. And we even talked about, not employing, but contracting with a translator at one point. And we decided, no, there are other resources out there, and this way, those resources bear the legal liability in case there's some sort of mistranslation. So actually, that's how we handle it. Also, what happens if you can't read the writing? Name, phone, email on the request form. Well, the right to know law requires that the person provide you with an address. It can be a physical address or it can be an email address. If you can't, if there's no way that you can reply to that person, then potentially you could argue that they haven't provided you with a legible address. And, I mean, how are you going to respond if you don't know who to send the response to? That would be somewhat difficult. So I would take it from there and say that they have not met that provision of the right to know law. And I think that is in, it's either section 701 or 703. You're really taxing my memory here, but I think it's one of those two sections that you're going to find that that requirement that they provide you with an address. Okay, good questions, folks. Keep them coming. And let me just make sure that I'm not missing any. Yeah, I think we're up to date here on the questions. Okay, moving on. All right, the other part of this definition of a record is any physical form or character, or regardless of its physical form. Let me run through that quick. I mean, obviously we're talking about paper records, but we're also talking about electronic records, which would be, like I've been mentioning here, emails, phone records, text messages. Okay, let's talk a little bit about deleted records, okay, just for the good of the order here. Your legal, under a case called, oh gosh, I can't remember. It's the Department of Labor and Industry, but I forget the guy's name on the other side of the equation. I really have to go back and look that one up. But essentially what it says is that, when you delete something off of your email, it's not really deleted. It doesn't really go away up until it's deleted from the email server that your agency relies on. And what that decision basically says, I want to say early. It's early versus the Department of Labor and Industry. I have to verify that, but I think that's the appropriate case. But what it essentially says is like, look, as long as you can still retrieve the message that was otherwise deleted using internal resources and internal staff, you have to do it. And in this particular case, the deleted emails were still available on the Department of Labor and Industry's email server. You do not have to employ like any sort of external forensic expertise or acquire any otherwise unusual software to retrieve otherwise deleted messages. All right, but if you can get it using internal resources, you have to. Now with phone records and text messages, that's a little different because you're relying on an external telephone carrier. The way the law is written is that you do not have to use a subpoena to get right to know records. Usually these carriers require a subpoena, and these messages are available. There's actually a federal law that says they have to retain all phone records and text messages. But under the right to know law, usually what happens is you to conduct a good faith search, you reach out to the telephone carrier. They tell you you need a subpoena. Under the right to know law, you don't have to use a subpoena, so you have conducted a good faith search, and end of story, like that. Okay. Now that, under different circumstances, maybe you want those phone records, they're going to require a subpoena, so you go out and get one, but not under the right to know law. Okay, questions popped up. How do you handle a request with a series of questions and one that does not request a specific record? Okay, Tiffany, remind me to come back to that because you're talking about specificity, and I'll try and come back to that. Okay. Blueprints, all I want to say is that it's possible, just because it's not 8.5 by 11, that it could be a public record. Audio recordings, again, it's based on the content of the message as to whether it's a public record or not. Security camera footage. This is interesting for police departments. Let me explain why. There is another law that you need to be cognizant of, Act 22 of 2017. Act 22 controls access to video footage taken from body cam, dash cam, or security camera under the control of a police department. Okay, so let's say everybody's in the same happy building. You've got the administrative side of the township, and then you've got the township police department, all in the same building. And there's a security camera that covers the front door. Now, if the monitor and the recording equipment are under control of the police department, Act 22 applies, which is a different law, not under the control or jurisdiction of the Office of Open Records. If the monitor and the recording equipment is under control of the non-police side, non-law enforcement, then the right to know law applies. And you would go through that footage and treat it just like a normal right to know law request. Okay, so that's the difference. And I'm going to talk about Act 22 here in the next slide. And then the final piece that I want to mention is social media, your Facebook pages, for the most part, or maybe a website. Or, there's other stuff that's being used nowadays, Discord, Instagram, and the like, all the stuff that your kids are using now. If you receive a right to know request for your Facebook page, that could very well be a public record. And there's nothing wrong with police departments using Facebook, okay? I think it's a good tool myself. Just keep in mind that if you post something to Facebook, there's a very good chance it's considered a public record. But fortunately, also within the right to know law, there's a provision that says that if this public record is already out there in the public domain electronically, all you need to do is say, yes, that's a public record, here's the link to it. You don't need to provide copies of something that's already out there in the public domain. You just point them in the right direction. The other thing to keep in mind is that if a record on Facebook has been deleted, let's say somebody put up something inappropriate, so you went in and deleted their post. Well, it is still available, okay? Facebook, like I said, most electronic records, when you delete them, they don't go away. Facebook is no different, and it's fairly easy to gain access to those deleted posts, so you would provide them, provided it's considered a public record. Okay, the link, would that be considered a denied request? No, actually it wouldn't be. Like I said, the right to know law allows the agency to provide the link to where that public record exists. And that's all you need to do to legally meet your legal burden to grant the request. Here's the link to where you'll find that record. Okay, would you simply tell them it does not apply? No, actually, you need to take a step back here. You are granting the request, but rather than provide a copy of the record, you're pointing them to where the record is on your Facebook page or your website. Okay, you're taking the easiest route to get them to the record they've asked for. Okay, you are granting the request. Okay, hopefully that explains it. All righty, moving on here. Like I said, let's talk about Act 22, dash cam and body cam footage, as well as security cameras that are under the control of police departments. Okay, technically I don't have to talk about this because it's not part of the right to know law, but we get a lot of questions from people about this, and we have a page on our website that explains it. The Pennsylvania State Police is the point agency on Act 22, okay? They also have a page on their website that explains it, and they have some people over there who are excellent resources on Act 22. But let me just give you the quick 411 on this. It's not covered by the right to know law, Okay, so if I want to get dash cam footage, I don't file a right to know request. I should be filing an Act 22 request. Now, when an Act 22 request is filed, the agency, meaning the police department, has 60 days in which, I'm sorry, let me back up. I'm getting this wrong. The requester must file the Act 22 request within 60 days of the creation of the footage. Okay, after 60 days, it's expired. You no longer have the right to file the Act 22 request. Or if you do file, it's going to be considered untimely. Now, the police department then has 30 days to respond to the requester. And the police department, unlike the right to know law, under Act 22, they can charge any fee they deem reasonable, including labor. If you're familiar with the right to know law, you cannot charge the requester for labor. Under Act 22, you can. And then if the police department denies the request, the requester appeals directly to the appropriate court. So if it's a local police department, it would go to the County Court of Common Pleas. If it's the Pennsylvania State Police, it would go directly to the Pennsylvania Commonwealth Court. The Office of Open Records has absolutely no jurisdiction under Act 22. You send an appeal to us under Act 22, we send it back saying, sorry, it's not under our jurisdiction. So, keep all this in mind. Act 22, you go to the County Court of Common Pleas for most of your appeals. Okay? Would you simply tell them that it does not apply? Actually, yeah, you could do that. You could do that if you wanted to. As long as it's clearly communicated to the requester that you need to file an Act 22 request with the appropriate law enforcement agency. Okay, let's move on. Okay, now we're up to the second hurdle. And after another sip of coffee, we have to answer a couple questions. The big question is it a public record? Note the difference. The first hurdle was, is it a record? Now we have to answer, is it a public record? But before we get to this second hurdle, we have to jump through 3 hoops. And the first hoop, we have to answer the question, do any exemptions apply? And if so, are we going to invoke them? All right. Within the right to know law, there are 30 exemptions listed under Section 708B. Now, for law enforcement purposes, there's only 3 that we really need to pay attention to. And I'm going to talk about those 3 here in a minute. But going back to all 30 of them, essentially an exemption is a definition of a record that can be withheld from public release at the agency's discretion. So if a person is requesting a record and it's covered by an exemption, if it falls into that definition, for instance, there is an exemption that says if by releasing this record, we would put somebody in physical harm, in danger, you can withhold it. Or there's another one that says if by releasing this record, it would compromise our computer system, we can withhold it. Like, somebody might ask for all the passwords for your computers. Well, we're not going to give those out. And fortunately, I think it's covered by Section 708B2. All right, so we would apply that exemption. But it's at our discretion, okay? We have the right to release those records, even if it is clearly covered by one of the exemptions. And occasionally that happens, okay? Yeah, there are examples I could give you, but we want to make sure we stay on point here. Okay, so the right to know law gives you the discretion to release a record, even if it's clearly covered by one of the exemptions.
So the right to know law is not a confidentiality law, all right? It doesn't say you must withhold these records. It says you can withhold these records. So we come up against this first hoop, and we have to answer the question, is there an exemption? And if so, are we going to invoke it? Now, if there isn't an exemption, we make it through the first hoop. If there is an exemption and we choose not to invoke it, we make it through the hoop. If there is an exemption and we choose to invoke it, we're saying, no, you can't have this record. It's not public, and here's the legal reason why. And we invoke the exemption and make the connection between that record and the exemption. Okay, then we come up to the second hoop, and this gets a little more complicated. Are there any federal or state statutes or a judge's order that make these records non-public? Okay, what this is saying is that even though there's an exemption within the right to know law, and we've chosen not to invoke it, if there is another law that says this record is confidential, then that law supersedes or trumps the right to know law and removes our discretion, and we cannot release this record. Now, for law enforcement purposes in Pennsylvania, I previously mentioned CREA, the Criminal History Records Information Act. Okay, CREA is a law that controls the majority of records that a law enforcement agency will have within their possession. Okay, let me give you a quick example here. Under the right to know law, there's no mention of criminal intelligence information. Okay, so if a law enforcement agency is keeping a file on suspected gang activity within the borough, okay, there's nothing in the right to know law that would define that. Thus, if I submitted a right to know request for your criminal intelligence information on gang activity, you would have to release it. However, CREA, this other law, says that this information is confidential and it gives you no discretion. It says you will not release this to any other organization other than a certified law enforcement agency. And you have no choice. If you do release it, you could come under criminal sanctions. So you need to be aware of these other laws. And like I was explaining earlier, we actually have a webinar on other laws that protect information that help you out with, health-related information, children, youth, and families, as well as law enforcement stuff. So usually, almost always, these laws do not give you the discretion. They say you must withhold these records, and you would refer to them in meeting your legal burden of proving why these records should not be released to the public. And then we come up to the third hoop, which is the record protected by privilege? Typically, for our purposes, this is attorney-client privilege, where you're dealing with communication between your solicitor and your police chief or your senior staff. Okay, you're constantly running up against legal issues where you're relying on the advice and guidance of a solicitor. So any emails, any printed communication of sensitive nature is protected by attorney-client privilege. You can refer to Section 305 of the Right to Know law. You can also refer to the rules of evidence in Pennsylvania, which clearly delineate that records protected by attorney-client privilege will not be released to the public. Okay, so now we're up against the second hurdle. And how have we answered these three questions? Well, if there are no exemptions or we've decided not to invoke the exemption, we make it through the first hoop. If there are no federal statutes or other state laws that say these records are confidential, we've made it through the second hoop. And then if the record is not protected by privilege, we've made it through the third hoop. Okay, we make it through the third hoop. Now we can jump over the second hurdle. When we jump over the second hurdle, we're saying, yes, what you're requesting is a public record, and we're going to release it. We're going to grant your request. But if not, we're going to deny your request, and I've explained how you go about doing that by using the appropriate tools that we've delineated thus far. Okay, questions popped up from Yvette. Our police department received a right to know from a convicted criminal in prison for employee file of an officer who arrested him and other materials concerning the officer. Township solicitor, some information is permissible for release for the right to know law. Is this correct? Well, I'm not going to second guess your solicitor. Okay, come on. But I will say in general terms, just because it's in a personnel folder does not make it confidential. Okay, because then we'd end up putting everything in a personnel jacket in order to hide it from public release. Let me put it this way. Most of what is in a personnel jacket is usually considered confidential. And David, you referenced the Personnel Files Act. That is appropriate, okay? But there can be materials within a personnel jacket that would otherwise be released. For instance, it's possible that an employee's record of training to show that they are in fact qualified to do certain things would be considered a public record. Okay, that's just one example off the top of my head. But for the most part, you know, I'm not going to second guess your solicitor, but in a general circumstance, what your township solicitor is giving you good advice. Okay, I'll simply leave it at that. But it needs to be analyzed on a case-by-case basis. And good for you to rely on the advice of your solicitor. Okay, keep doing that. What about redactions, such as investigative or juvenile information in the body of a report? Partial denial. Francis, yes. A redaction is when you've decided to release an otherwise public record, but there is a sensitive piece of data within that record, like the name of a juvenile or a social security number, something like that. So you black it out, okay? That redaction is considered a denial because you are denying access to a piece of data. So in your response, you say, we are granting your request, but we are also redacting this piece of information. And you would explain what it is you're redacting. We have blacked out the name of a juvenile, or we have blacked out a social security number. Okay, and then you would include language, if you believe this to be a denial, you have the right to appeal, and here are your appeal rights. That's how we handle it. Okay, but that's a really good question. Redactions are considered denials under the right to know law and appropriate case law. But you tell the person what it is you're redacting, and usually a reasonable person will understand. Okay? All right, so we've made it over the two hurdles. We've granted the request. I want to take some time to talk about the three exemptions that most law enforcement agencies need to be aware of and typically are used in analyzing whether or not records should be released in response to a right to know request. The first one is the most common. It's 708B16, which defines criminal investigatory records. Okay. If a record is crucial to a criminal investigation, whether it's an active investigation or one that's closed. It could be a 25-year-old cold case. Okay, this exemption still applies. There's no statute of limitations on it. Okay, you could deny access to those records based on the fact that they are part of a criminal investigation. And you would apply the 708B16 exemption. Now, it does not include blotters or incident logs. Okay, blotter is an old term used for basically what amounts to a shift diary. If you have a log that says, okay, at 3:15 a.m., this particular officer was dispatched for a noise complaint, that is an incident log, and that clearly is delineated as being a public record under the right to know law. The other thing that you want to keep in mind related to this exemption is that there is case law under the Pennsylvania Commonwealth Court issued a decision, I think back in 2012. It might be 2010, but anyway, that decision basically says that police incident reports, not blotters, but incident reports, are considered investigatory. It says they're inherently investigatory. Therefore, the B16 exemption applies. Thus, listen to me, police incident reports are not considered public records. Okay, let me repeat that. Police incident reports are not considered public records based on existing case law. Then we come up to the next exemption, which is 708B17, non-criminal investigatory records. Okay, these are investigations that might be assigned to the police department where there is no inherent criminal activity, or no evident criminal activity. Nevertheless, it is an investigation that has been conducted by the agency. And if the agency has legal authority to conduct said investigation, then this exemption can apply. Okay, so let's say you're a small borough, there's no codes department, but you receive a complaint from someone about their neighbor's yard. It's a mess, they haven't cut their grass in a couple months. We need to do something about this. Well, who gets assigned to go look at the yard? The police department, okay? Non-criminal investigation, it's more of a codes thing. Okay, so they go out and say, yes, I investigated, I looked at the yard, the grass needs cut, et cetera, et cetera. So that is a non-criminal investigation. Well, then someone files, let's say the property owner files a right to know request. I want to know who complained about my yard. Okay, well, under this exemption, that information is protected. Okay, so non-criminal investigation. But keep in mind, you have to have statutory authority to conduct said investigation. You can't just say, well, that's something we're looking into, so we're going to call it an investigation. No, that doesn't work. All right, and then the final exemption that you need to be aware of is 708B18, a very black and white written exemption that protects all of the communication going back and forth with a county emergency management site, a 911 center. Not just county, I should correct that. Any emergency dispatch center, whether it's through a county 911 or if you happen to have locally dispatched police reserves or police resources. Any of the phone calls, recordings of phone calls, any recordings of the radio communications, it's clearly covered by this exemption in the right to know law. Most of the time, the public cannot get access to this. Well, then you're saying, well, wait a minute. I've heard these phone calls on the radio, on television and public radio. How's that happen? Well, the emergency management director has the discretion to release those recordings if it's believed it's in the public interest to do so. Maybe it will help solve a crime, prevent a crime. Maybe it's just in the public interest to, allay public concern about some issue. So we're going to release the recording. Okay, they can do that, but they have very much strong interest in not releasing those records, and it's protected by this particular exemption. Okay, child line reports considered non-public. Yes, they are, but that's under the Child Line Act, okay, the Children, Youth, and Services Act, not the Right to Know law. Yeah, I did just answer that. Adam, for 911 recordings and dispatch logs, I deny and refer the requester to our dispatch center. Yes, because they would have possession of it on the premise that we may have those records, but are not the owner. Is that a good practice overall? No. Let me think about this. Okay, well, first, the question is, do you in fact have possession of the records? If you have the recordings, then you're in possession. Typically, those recordings, though, would be, well, maybe you do for a criminal investigation. If that's the case, then they are investigatory records. You could apply the B16 exemption. But take a look at that exemption, Adam, and read it, and you'll see it's very clear whether you as the department are in possession or the 911 center is in possession. The B18 exemption would apply, okay? It comes down, based on the premise of your question, it comes down to what do we have possession of? And usually it's the 911 center. But if by chance your department has a copy of the recordings, then it would be protected by, usually by the B16 exemption. And you could use that. Yeah, okay, good. All right, let's move on. We're getting close to the end here. Okay, appeals. If in your denial, the department has invoked the B16 exemption, citing that the records requested are critical to a criminal investigation, then the denial should indicate that the person's appeal rights is to file with the county district attorney. And they will usually have an assistant or deputy DA assigned as their appeals officer. And they will then rule on the appropriateness of the denial. If the request is denied for any other reason, the appeal comes to the Office of Open Records. And remember that the person has 15 business days to file their appeal with either party. And in some instances, it might be both. Okay, it just depends on what's the basis for the agency denying the original request. If it's B16, it goes to the county DA or Pennsylvania Commonwealth Court. If it's anything else, it comes to the Office of Open Records. Okay? All right, let's cover costs real quick here. The Office of Open Records is statutorily required to establish a fee schedule. That fee schedule is on our website. Down and dirty here real quick. If they're requesting hard copy, you can charge up to 25 cents a page. If they're asking for electronic records, there's no charge for electronic records. Everything else, like postage, is actual costs. You cannot charge for labor or redactions. Any other legislative charges take precedent. Okay, what am I referring to? Mostly accident reports. Okay, if there is another law that has a fee schedule for records that are requested from your agency, that fee schedule supersedes the Office of Open Records fee schedule. Accident reports are a good example. Someone gets in a wreck, their insurance company requires that they get a copy of the accident report, so they ask you for it. It's not 25 cents a page. Rather, under the Pennsylvania Motor Vehicle Law, they have a section with a fee schedule, and it essentially says any accident report is $15. So the police department charges $15, not 25 cents a page, because that fee schedule supersedes our fee schedule. Okay, that's how that works. Okay, Julie, a call log, time and date would be a public record for noise complaints. Yeah, if that's considered a blotter. Related names, addresses, and the police departments connected would be exempt, correct. Yes, again, it depends on the specific record that's being requested, but the privacy of the people related to the complaint typically is considered exempt. Now, if there is an arrest, then it becomes a court record, and court records are accessible under what's called Rule 509. Okay, court records are considered public if there is an arrest made, but you do that by going through the courts, not through the right to know process, just so we're clear on that. But Julie, you're on the right track here with your question. Okay. All right, we're at the end of the presentation. I want to go back and see whether or not that one question that was asked. Okay, bear with me here. Prison. Okay, we answered that. Yeah, the reason being, I promised I would go back and answer this question. Oh, somebody, yeah, folks are logging out, so it's messing up the chat. This could be a problem. Okay. I'm sorry. The way this new software we have, if someone logs out, it shows up in the chat feature. There's no way I can delete that. Convicted criminal, I answered that. Social media, writing, snail mail. That. Children needs a family, I answered that. Okay, I'm not finding the question. I go through these one more time. Okay, other things have come up here. So I'm just going to answer these. And if I didn't answer any of the questions that someone put in earlier, type it again. Okay. Okay, Julie, I answered your question. Can you explain third-party notification procedures? Oh my gosh. Yeah. In a nutshell, here's the deal. If someone requests a record, first off, and usually if there's a third party involved, okay, now in police department records, oh boy, how can I put this? Okay, if by releasing the record, you would provide third-party information that may be proprietary, that may be considered confidential, that may be sensitive, you have an obligation to notify that third party that you're considering releasing that information and that they have a right to participate in the right to know process. So that, let's say it's proprietary information provided by a vendor to your department, and someone requests a copy of that information. You would notify the vendor that we're thinking this might be public, but we're giving you the opportunity to weigh in. So they could participate in the process as an interested third party and raise objections to the information being given out. If you consider their objections valid, then you would deny the request based on the objections that they raise. And then if it gets appealed, again, the third party could request to participate in the appeal. And the burden would kind of fall on them to make the case that the record is not public. Okay, that's kind of how that works. Now, if it involves basic right to privacy, like a name of a victim or someone who reported a crime, typically that would be protected anyway under the investigatory provisions. or under the constitutional right to privacy. Okay, you don't just give out names and addresses, that kind of stuff. Chief, I'm not clear on any other possible scenarios that involve third party. Hopefully I've answered your question, but that's kind of the approach I would take. If I didn't answer your question, you can type in more or maybe reach out to the office and seek some guidance there. Okay, I believe this was how do you handle a request with a series of, oh yeah, you're right, there we go, specificity. Good one. Okay, under the right to know law, I think it's section 701, it could be 703, but it says, and I paraphrase here, that the right to know request needs to be specific enough that the arrow can figure out what it is the person's asking for. Okay, so if it's written vaguely, you can potentially deny the request based on the fact that you can't figure out what it is they're asking for. You need to be able to identify a specific record based on the question. Okay, so if someone submits a right to know request and it's a question, they're not asking for a record, but it's like, why do you charge $25 for a parking ticket? Okay, well, they're not asking for a record. Now, maybe you could go back and research the statutes, but you're not required to conduct legal research under the right to know law. And if they aren't asking for a specific record, or if you can't figure out a record that answers their question, you can deny that request because it's not specific enough. And the other thing you're saying, what if it's a series of questions? Well, yeah, I mean, you're kind of clear with your question there. And the answer is, if you cannot determine what the record is that they're asking for, it is possible that you can deny the request based on a lack of specificity. And you would refer to either section 701 or 703 of the right to know law, okay, as your basis for denial. And essentially what you're saying is, I can't figure out what it is you're asking for, therefore we're denying your request. All right, but here is a good example where you want to bounce this off your solicitor, okay, because there's a lot of case law on specificity where the courts have provided guidance, and in some instances, we're splitting hairs, okay? So don't take, I'm explaining the approach you should take and what specificity is, but your solicitor should probably be the one, if you're going to raise specificity as a basis of denial, your solicitor should be the one to determine, whether or not it's appropriate to rely on specificity as the basis of your denial. Okay, Matt, if a record doesn't exist, I am not required to create such a record, correct? Yeah, as a rule of thumb, that is correct. However, there's always an exception, and there's case law on this. It's Gingrich versus the Pennsylvania Game Commission, where there was an exception. But as a general rule of thumb, Matt, that's what I'm going to say. The other thing I'll say is that sometimes the easiest thing to do is just create a record. Let's say someone says, I'd like a list of, I'd like a list of all the vehicles that your department currently has, and you don't have such a list. Okay, so you respond back that we're not in possession of that record. Well, their recourse is to file an appeal. And then that's going to take up all kinds of resources and time and money of your department, when maybe the easiest thing to do is simply create the record. Just give them a list of the vehicles, okay? But it's up to you. I'm always looking for the easy way out. And sometimes the easiest thing to do is just give them a record, okay? Just grant their request and get them out of your hair. Because the alternative is for them to file an appeal, and then, nobody has time for all that. So again, but it's up to you as to how you want to respond to stuff like that. To answer your question, the quick answer is no, you do not have to create a record. Okay, yeah, we've got a big one here. Let's see what people are asking. Okay, all right, someone is helping you out here. Section 1605, in which the responding request for access to agencies shall not be required to create a record. Yeah, that's appropriate. And yeah, you're referring to case law. Okay, so that's good. Okay, but bear in mind, it depends on the extent of what they're asking for. And sometimes the quickest way to get someone out of your hair is just tell them what they want. Okay, what's the other one we have here? There's a new, yes, we have a new open records request form. We receive a request on the old form. Should we ask them to resubmit it? New form and then start the response period. You can if you want to, okay? But you can also accept the old form if you want to. The reasoning for the new form is due to this FOIA Buddy software that most people are now familiar with. And it comes down to the anonymous request issue, and the fact that agencies can deny an anonymous request where the requester is not identifying themselves. So our form kind of goes into a little more detail in delineating that. If you think, even though they're using the old form, it's a legitimate request, you can go ahead and process it. But if you pass a policy that says we will only accept the new OOR form, you can do that as well. Okay, it's up to you. We afford agencies a fair amount of discretion in how they administer their open records programs. So there's nothing that says you must only use the new form. You can use the old form if you want to, but what we're doing is giving you a tool to help deal with these anonymous requests, because our form specifies that, we kind of push the button that says you need to identify who you are. And there's case law that supports that. Okay, so Nathaniel, that's our take on that. The new form is in response to FOIA Buddy and the whole issue of anonymous requests, because if you're getting inundated with these electronic requests, they are legitimate, okay, they're not spam, but in many instances, the person is not identifying themselves. What we're saying is that you can require the person to identify themselves, and you can use our new form as a tool to do that. So that's what's going on there. Okay, other questions? I haven't seen anything pop up here. So we are at the end of the presentation. Lots of good questions here, guys. You kept me on my toes. But I do want to point you to our website, where we've got a number of resources, including the law enforcement guide that goes into a lot of detail on what we've been talking about here this morning. You can also take a look at the citizens guide, and take a look at our final determinations database. If you're curious about how we have ruled on B16 cases that have come our way. As a matter of fact, we do have a separate database just on how county district attorneys have ruled on B16 cases that you can go in and take a look at. If you're an agency open records officer, we've got a guidebook for you, 78 pages, downloaded for free. Everything's there. Take a look at our training pages for more opportunities like these other webinars that I've been talking about. And if you are a real geek about transparency, you can subscribe to our X feed. And every morning at 7 a.m., we will wake you up with all the news of the day on the right to know law, on the Sunshine Act, on other transparency issues nationwide. Finally, if you have a question and you need to get a hold of us, call us, okay? Like I said, you'll first go to our admin staff, and they can usually get you headed in the right direction. So I want to thank everybody. We'll be back in 2 weeks with another webinar, either on the right to know law or the Sunshine Act, I think is what's coming up next time. Thank you for everything you do. Thank you for the good questions today. I'm going to sign off now, and everybody take care. Bye-bye.